Good afternoon to all of you who are tuning in on the East Coast, and otherwise, thank you for joining us wherever you are joining us from. We're glad to have you. It's going to be 30 minutes of good content for you, I'm confident. And if Kathy, you go to the next slide, I will walk the group through. Thank you. Um, just before we begin, however, this is my first broadcast with you during May. We are absolutely excited that you have stuck with us and been with us through this first part of the year. We now have about 5 months of change underway with our slightly adjusted format where we are working with 30 minutes of presentations. So I just note that if ever anyone has feedback and otherwise concerning both the program scope and its format, feel free to reach out to me offline. We're always interested in hearing from you. Getting to the subject matter for today, I'll be talking with you first about the agenda as I walk through this, and then I'll move into the budget, both New York State and what's proposed at the federal level by House Republicans. There's some interconnection there. Then Alyssa Christian will be back with us from our Syracuse office, and she'll be talking about an FTC issue as she has addressed in front of all of you from time to time. And this is actually language that became enforceable yesterday, so it's very timely. And then we'll have Angelo Catalano on with us as well. Angelo is both new to the firm and new to the program, and we're really thrilled that Angelo both joined Bond and can present to all of you, so all of you get a chance to know him a bit better. Also sitting in Syracuse, and Angelo is going to be talking about public employee leaves of absences, getting into some of the nuances there that he knows well from his practice area. So with that, Kathy, knowing that our plan is to wrap up in 30 minutes, let me walk through the budget and what we can tell you about it. It finally closed. The governor signed it last week. It was quite protracted in a number of ways relative to years past. In specific, of course, I came to you 2 weeks ago and indicated that we had a budget deal. At that point, it was quite evident that we did, and there were agreements in principle, but there were still lots of negotiations happening, as it were, under the hood. And so the final agreement didn't actually happen until about a week to 10 days after I was last with you. And here's what we can tell you in summary. I won't go through every provision because there's just not enough time, but here are some of the highlights. We're still looking at a $254 billion total amount, which includes federal funds that are mixed into it. And I've mentioned some of these, and some of these are new, so I just want to kind of highlight the broader picture so you have a sense of issues that may be important to you and your businesses. And if there are issues that you have questions about, by all means, ask in the chat, and we will do our best to follow up with you in future programs. But first, we talked about bans on cell phones during the school day. That is something that the governor was particularly fixed on seeing in the final budget, and it made it. And I was talking with some colleagues in our school law practice earlier today. It's going to be challenging to see how this is all implemented on a jurisdiction by jurisdiction basis. There's lots of I's to dot and T's to cross in terms of the operations, and so that work begins now. I mentioned as well previously that there are some penalty enhancements, that are found in the budget for masking during crimes, but these are relatively modest relative, that is, to what the governor had initially proposed. This is in connection with some of the protest activity that we've seen over these last few years that has involved individuals who are masking, and there's been a lot of public debate about that. Of course, we don't have the room here to go into that debate, but this is a specific outcome that is intended to be a compromise position of sorts. And then discovery law changes also were a big part of what the governor was hoping to see through in this budget, and it was a reason why we saw some of those delays. Essentially, some of the reforms of a couple of years back have been dialed back, not in totality, but there are some significant revisions that shift things a little bit back more toward the way it was. And that, again, was important to the governor. Involuntary commitment standards we talked about previously, and those are also very much part of this budget in a way that the governor is happy about. Down here in New York City, Mayor Eric Adams is also on the record publicly about those being important to him and the administration he leads. So there's, of course, a lot of conversation about whether and how this all gets implemented, and we shall see as we move forward this year. I mentioned those inflation rebate checks in my previous update; those survived, as well language that works to unify the gubernatorial ticket. That'll require some further maneuvering, but essentially the intent is set by way of this budget. And then other things that have come up that are worth your attention. Civil service exams are a way for individuals to enter, of course, public service and otherwise be set in positions that are based on how they score in those exams. The state is continuing to waive costs in certain instances in order to encourage people to come into public service. Following COVID, there was a significant drop in those who remained in service and otherwise who have chosen to go. And so this is a way to counter that, or at least an attempt to do so. Another colleague of mine mentioned, so I'll flag to all of you that we've in the budget seen an increased amount allocated to the Division of Human Rights, which has a key role, we expect anyway, or will, in helping to move adjudications more quickly through that body. Sometimes they've been taking as long as 2 years on fairly straightforward matters. And so this is, in part, we understand, a means of trying to respond to that. There are also higher unemployment insurance caps, some provisions around child labor. Not enough time to get into them, but just note that's there too. School aid was a big item for many around the state, and that is also going to jump up quite a bit. There are now disclosures in the AI space concerning chatbots, just so that ostensibly people know if they're speaking, as it were, or otherwise communicating with an entity that isn't human. That's intended to be part of how the governor over time and the administration looks at those issues. There are modest COLA increases, cost of living increases for human service workers. Lots of concern among the advocacy voices, including trade associations, that's not enough, but there are increases there. Similarly, with healthcare, whether Article 28 or other healthcare delivery, there are fairly significant increases built into the budget, but they are contingent on an MCO tax, which is really important. Let's get to that in a moment. And there's also a bit of change regarding the frequency of pay for manual laborers. Some colleagues of mine in the Labor Department have recently written about that, and you may be hearing more about that on the webinar in a forthcoming broadcast. But let's go to the next slide, please. I remind you that the Consumer Direct Personal Assistance Program was not an issue that really was covered by way of this budget and remains unsettled terrain. MTA financing is still, a really significant, as it were, big ticket item. And there was that compromise concerning payroll levy that I had noted. What also didn't make the budget were workforce flexibilities, in the healthcare space. There was a lot of discussion during the pandemic about lessons learned in terms of how we could have practitioners working at the tops of their licenses and otherwise in more creative ways around the state. Some provisions around flexibilities there did not ultimately make it. Other things to think about, though, is that all of this is happening, of course, in a context, a federal context at that. We're past the first 100 days of the Trump administration. We are now a bit more deeply into the post-Biden era. And what we are seeing is essentially a budget that is built around the possibility that federal change may still be forthcoming as the year progresses. There are mechanics in the budget that specifically speak to what happens if there's a more than $2 billion shortfall predicted, and it gives the governor certain powers working with the division of the budget. And then there are separate, contingencies built in around that managed care tax that I mentioned previously. It is a big part of how the healthcare increases are financed. And if the federal government decides that it is ultimately not in favor of allowing those tax dollars to come through New York State, as had been approved at the end of the Biden administration, there will be a significant hole, as it were, to fill, and those increases could very well be rolled back. So we're a bit in wait and see. As it relates to what might be happening at the federal governmental level, in the process of developing the budget proposal for the federal government, which runs on a slightly later timeline, the Republican House has issued a proposal that would substantially cut Medicaid and also would add in new requirements around work, drawdown restrictions vis-a-vis the states, so that the states ultimately, are going to be less fully financed by the federal government, and certain limitations on who can actually enroll in Medicaid. So we're watching all of that very closely. We'll have very significant connectivity to what happens in the rest of the year here in New York. So with that, knowing again that we only have 30 minutes with you, let me turn to the next speaker, and I will be back to you in order to make sure that as we learn more over the course of these next weeks, you have the opportunity to get updated with us. But for now, let's turn to Alyssa Christian, who is with us from Syracuse, and the junk fees rule is going into effect, or actually it has as of yesterday. Tell us a little bit more, Alyssa, please, as you would, what that's about and why everyone should be hearing about it from you. Looking forward to learning myself. Thank you.
Thanks, Gabe. Happy to be here as always. So, as Gabe said, the Federal Trade Commission, which is the government agency tasked with addressing problems that affect consumers, has implemented this new rule. I'm sure you've all heard in the news. It's a topic that is really, really prevalent these days. These junk fee rules, or junk fees, which are pretty much hidden fees, and this rule is aiming to address that. So Kathy, can you have me go back? I know I have control, but it's not. Okay, thank you. So again, most people know this rule as the junk fees rule, but the official name is actually the rule on unfair or deceptive fees, and it's codified in the Federal Register in Part 464. As Gabe mentioned, it took effect yesterday, so we'll see going forward how much it is enforced by the FTC, but I want to start off by demonstrating just how limited this rule is. With junk fees being so prevalent, there's been a lot of discussion as to whether this should apply across all industries, but for now, the FTC has made this rule very limited in scope. So due to these bait and switch practices being especially prevalent in the accommodation and live ticketing industries, right now, this rule is very narrow in scope, only applying to the advertisement and sale of live events and short-term lodging. And I will get into what exactly those are throughout this presentation, but I just wanted to start off by saying just how limited this is. And this rule really is an effort to prohibit just the misrepresentation of the costs and of consumers being drawn in by an originally advertised low price, only to find out that the total bill is significantly higher due to fees. So, like I said, we need to get into what these definitions are of live event tickets and short-term lodging, since this rule only applies to those two industries. A live event ticket is admission for something where audiences are going to watch an event as it occurs. So a main example would be concert tickets. It's that problem where no one likes to think that they're going to get tickets for one section of a concert for $50, only to find out once they make it through the checkout process that what they're actually going to be paying for this concert is closer to $100 after all of the fees. The definition does exclude anything that's pre-recorded, so generally, movies will not be considered a live event and will not be subject to this rule. And then the definition of short-term lodging includes any temporary sleeping accommodation, but big exclusion would be landlord-tenant relationships will not be impacted by this rule. So even if it's just a short lease extension, there is a carve-out. It's not going to be considered short-term lodging. Now that we know who this rule applies to, I want to go over some definitions of what ancillary goods and services are. So, and this will become more important as I go through this presentation, but if the purchase for the underlying goods and service would be rendered almost useless without buying something else, then it's going to be considered a mandatory ancillary good and service. So an optional one would be something like an extra, an add-on, maybe a VIP package to a concert, something that someone might splurge on, but it's not really necessary. And that's where we get the optional ancillary good or service. Now, on this slide, we're going to get into what the crux of the rule actually is, which is when selling or advertising live event tickets or short-term accommodation prices, the total price must be displayed. Now, the total price comprises of that underlying good or service plus any mandatory ancillary fees. So again, a mandatory ancillary fee would be something that you need to buy in order to use what you're actually purchasing. Now, this price is different from the final price because the final price is what the consumer is actually going to, shell out to buy this. And so the final price comprises of everything in the total price plus any optional ancillary fees plus any allowable excluded fees. And so allowable excluded fees would be taxes and shipping, which makes sense because those vary based on where the consumer is. So those are allowed to be excluded from the total price, but the final price needs to include them, and that final price needs to also be displayed at least as prominently as the total price, if not more prominently. On this slide, I'm going to go over some examples of what these mandatory goods and services are. And again, it's when fees cannot be reasonably avoided, that's going to be considered mandatory. So first off, there are fees that are required by the seller. So if a resort is requiring every guest to pay a resort fee, whether or not they're going to be using the amenities, that's considered mandatory. There's no way for a consumer to get out of it. If a reservation can only be made on an online platform, but payment is required upon reservation, there's no reasonable way that the consumer can pay cash. So if there's a credit card surcharge, that's going to be considered a mandatory fee as well. Now, remember, we classified ancillary goods that are just extras as being optional. So those that are needed to make the underlying purchase function as intended will be considered mandatory, whereas if they're just an extra, that's optional. So an example would be a hotel. It's pretty reasonable to assume that it's going to have pillows and blankets, but if there's an additional linen or bedding fee, that's going to be necessary to make the purchase of a hotel room useful, and that's going to need to be included in the total price. The second prong of this rule has to do with misleading fees and when optional fees, how they're going to be presented. So remember, fees that are not included in the total price must still be disclosed. They must still be included in the final price. But in addition to just disclosing the price, you have to disclose what they are and give information about the nature and character of them. So this would be saying anything that's a material characteristic that would affect the value that the consumer would care about needs to be disclosed clearly and conspicuously. And clearly and conspicuously is defined as being difficult to miss. So for example, it would be misleading for a hotel reservation to claim it's fully refundable without warning that there's actually a fee for, getting a refund, or that it's only refundable for 24 hours. The rule also prohibits vague terms such as a service fee or a convenience fee that doesn't accurately inform the consumers what that fee is. And then it also addresses whether this rule, you cannot say if the fee is optional when it's really mandatory, or it's mandatory when it's really optional. And the rule goes into enough depth to say that if consumers are automatically opted into an optional fee, it's not optional, it's going to be mandatory. So it's just adding an extra step to this, that all fees must be properly disclosed to make sure that consumers really know what they're paying for. So that's all I have on this, but we will see how the FTC ends up implementing this, and if those will expand to any other industries. Thank you.
Thank you so much, Alyssa. Great background. And as you point out, this is new as of just yesterday. So please come on back if we see more as to what the application looks like. In the meanwhile, have a great afternoon. And let's turn to our final speaker for our program, who is new to the program in a way. This is Angelo Catalano. Angelo is senior counsel in our Syracuse office. Angelo had heard about the Tuesday webinar when he was at another firm before coming to Bond. He and I were talking about that a bit yesterday. And so I'm glad that Angelo gets to be a part of it here, and that all of you get to meet him and to hear a little bit about what are the hot topics in his practice. So Angelo, welcome to the firm and welcome to the webinar.
Thank you, Gabe. I appreciate it. And good afternoon, everybody. I'm frequently asked about employee health, ability to work, and the ability to question an employee's capacity to work. So I'm going to focus today on a couple of these issues, particularly for public sector employees, because that's where we have the most laws that specifically direct our abilities to question these things and how to address them going forward. As a reminder, this is kind of a surface level review since we only have 10 minutes of time here. The first one to keep in mind is FMLA. Most employers are aware that FMLA applies for employers with 50 or more employees within a 75-mile radius, but it specifically says it includes all public sector employers. However, despite FMLA covering all public employers, that does not mean all public employees will actually qualify for FMLA. They still need to have 50 employees within a 75-mile radius in order for the employee to qualify for FMLA benefits. So it's kind of a distinction there in the law that the law contradicts itself with who actually qualifies. I'm not going to focus too much on FMLA because there's a lot to unpack there. But just as a reminder, it allows for 12 weeks of unpaid leave for employees with certain qualifying conditions, and it allows them to keep their group health care benefits during the course of that. As a reminder, every time we talk about FMLA, you should also remember that you also have to consider the Americans with Disabilities Act when addressing FMLA issues. And my reminder there with employee leave is that even though somebody might exhaust their 12 weeks of FMLA leave, it is often going to be considered a reasonable accommodation to allow that individual to have an additional 4 to 6 weeks of leave after they've expired their FMLA leave, if it's considered reasonable or expected that they will have a full recovery or be able to return to work with or without a reasonable accommodation after that FMLA has expired. So we always have to keep in mind that 12 weeks very often can be extended for a longer period of time if it's a reasonable accommodation to grant that leave of absence. So now turning to the specifics that are really applicable for public employers, our civil service laws, section 71, 2, and 3. Civil Service Section 71 is a law which allows employees 1 cumulative year leave of absence for a work-related injury. The key here is that even after the 12 weeks of FMLA has expired, the employee is still entitled for a year leave of absence before they can be removed from payroll. They don't necessarily continue their benefits, they don't continue to receive pay, but they're still on your roster. And as is always the topic for public employers, you have to make sure you check your policies and collective bargaining agreements before taking any action. But in essence, what Civil Service 71 does is it allows the employee 1 year of absence for a work-related injury or illness. And then after that year has expired, if they are removed, the law permits them 1 additional year to essentially get healthy and apply for reemployment, and they're given preferred status for that reemployment. Civil Service 73 is the sister statute to Civil Service 71 that allows an employee 1 consecutive year leave of absence for a non-work related injury or illness. We often think of this one when it comes to cancer. Just like Civil Service 71, 73 allows an employee 1 year leave before they can be terminated. And if they are terminated after the 1 year, then 73 still permits them an additional year to essentially get healthy and apply for reemployment and have a preferred status during the course of that reemployment time. Civil Service 71 and 73 have both been the subject of a lot of litigation in the last couple of years for public employers. Both have been deemed mandatory subjects of negotiations. Which parts of those are mandatory subject of negotiation is still up for question and up for debate and is still being litigated. But you should keep in mind that if you have not already used Civil Service 71 or 3 in the past, you're likely going to be have a demand to bargain over it as soon as a notice goes out to employees notifying them that your intention is to use Civil Service 71 or 3 to remove an employee from service. Sandwich between 71 and 73 is Civil Service Law Section 72. Civil Service 72 allows a public employer to send an employee for medical examination if the public employer is questioning the employee's ability to continue to perform their job duties. In the schools, we also have Education Law 913, which essentially is the same thing as Civil Service 72, but with slightly different procedures. This only applies again to non-workers' compensation cases, and it has very detailed specific requirements of what steps an employer must follow, what kind of notice he must give an employee, and how an employee can challenge a determination after a 72 exam. Essentially, we send the employee out for an exam with a physician, and the physician tells us whether or not that individual is capable, is ready to return to work, or should be working. It allows us to remove the employee immediately from work if we have significant questions as to their safety, the safety of others, or if they are substantially interfering with the workplace. The number one thing to remember with Civil Service 72, in my opinion, is that you as the employer should never be diagnosing the individual. You're going to be documenting your observations as it relates to the individual so that you can then put together a letter to a physician explaining to the physician what your questions or your concerns are, and you're going to explain to them what you've observed. And I'll give you a real life example to kind of wrap up Civil Service 72. We had an individual who was out of work for an extended period of time due to a heart condition. After several months off due to his non-work related heart condition, he returns to work. And within the first 2 months of being back to work, he has several days that he has to call off sick because of unspecified reasons. And he had to have an ambulance remove him from work and take him to the hospital due to chest pains and shortness of breath several times within those first 2 months back to work. The municipality became concerned as to the individual's ability to continue working, so they documented these issues and this history, sent him to an examination for the physician. The physician ultimately determined, no, this individual is a significant risk to himself and to others by being at work because of his underlying heart condition, and he should not be at work. We followed the Civil Service 72 procedures, removed the individual from work, we challenged it. We had a hearing, a due process hearing, determining that he was properly removed from work. And then after a year of absence, he was removed entirely under Civil Service 73. And that's the way the process is meant to work. You observe what your concerns are, you explain your concerns to the physician, and the physician is the one who ultimately renders a determination. You should absolutely discuss any of these issues with your labor counsel if you have any questions about removing somebody or questioning someone's ability to work. We always have issues and concerns as it relates to discrimination or retaliation. So whenever you're addressing employee health and safety concerns, make sure you consult with your attorney for those issues. Thank you very much.
And I want to thank you, Angelo, for that helpful introduction to some of the issues in your practice. And for those of you interested in reaching out to Angelo, his contact information is up there. And Angelo, please come on back to the program whenever you have more to share. We would look forward to having you. I know our audience would too. So with that, Kathy, let me turn to the next slides, please. If you can go one past that, please, I'd appreciate it. And thank you. What we have here is a reminder to all of you that our workplace seminars continue. I saw a number of you in New York City yesterday where we had a seminar, and there's one in Rochester today, I think indeed right now. There are others upcoming. I will be at the Westchester one on June 4th, and colleagues of mine will be staffing the many others. We hope that you can join us because the reporting back we always get is that these are informative and worth the time. So if you haven't registered yet, please consider doing so. And other than that, I just wanted to ensure that all of you have access to our email addresses if you have questions for us. And know that I'll be back with you in about 2 weeks' time, right after the Memorial Day weekend. In the interim, Carrie Langan will be your host, and we are grateful for your continuing loyalty to the program. Thank you so much for taking the time to tune in today. Have a great rest of your day.